Good morning, everybody, and welcome to the latest Archor webinar. We're going to be talking to you today about the court's approach to disputes under NEC contracts. I'm sure most of you by now know Archor. We formed in summer 2021. On the screen there, you will see our 6 founding partners. The webinar this morning is going to be delivered by myself, Carolyn Porter, and my colleague, Ollie Worth. So just some housekeeping before we get started. This webinar is being recorded and it will be available after today if anybody wants to watch it again. Also, if you have any questions that arise during the webinar, we will be doing a Q&A session at the end. So please type any questions that you have into the public chat that you will see on the right-hand side of your screen. So Ollie and myself are going to be running through 10 cases, 5 cases each, covering some key issues that have arisen under NEC contracts. So without further ado, I will pass you over to Ollie for the first case.
Morning, everybody. So the first case I'm going to look at today is Costain and Tarmac, and what better way to start than with everyone's favourite NEC clause, the obligation to act in a spirit of trust and cooperation. But before we get to that, this particular contract looks at this clause 93.3, which is a fairly unusual clause, but effectively it requires that if there is a dispute arising, the parties must notify the other within 4 weeks of becoming aware, and if they fail to do so, then neither party may subsequently refer it to the adjudicator or the tribunal. So effectively, you have 4 weeks from becoming aware of the facts to let the other party know, and then you can go to adjudication. So this contract concerned a subcontract under which Tarmac was supplying a safety barrier for the M1 to Costain for its main upgrade works. A defect was identified in October 2014, and Costain ultimately, after quite a lot of discussion, started a claim for £5.8 million worth of damages. Tarmac suddenly, well, not suddenly, but legitimately said this claim is time barred under clause 93.3, and that left Costain with quite a large problem. So what did it do? It tried to argue that clause 10.1 should override the obligation in 93.3. Now, clause 10.1, as I've said, is the Marmite clause of NEC contracts. It's the one which NEC fans love and say is the most important part of the NEC suite. And it's the clause which those that aren't such big NEC fans say simply has no real meaning, is one of those just fluff clauses which you can just look past and look at the more concrete ones. But here, Costain was clearly on the side of the NEC fan club and said that it meant that clause 93 had to be read in the spirit of trust and cooperation. So effectively said that Tarmac should have told them that the 4-week time period was coming up and give them a chance to put their claim in. Quite a novel argument, I would have thought. So the court endorsed what was commented in Keating NEC 3, which is one of the leading textbooks, and said that the term of mutual trust and cooperation suggests that whilst parties can maintain their legitimate commercial interests, they must behave so that their words and deeds are not attempts to improperly exploit the other party. So what it was saying was clause 10.1 effectively meant that unlike most contracts where parties can stay silent and allow parties to walk into traps, there may be an obligation sometimes to not let that happen. However, the court did say it didn't go quite as high as Costain wanted. It said at its highest, it meant that the subcontractor, Tarmac in this case, shouldn't do or say anything that was lulling the other party into falsely believing the time bar was either inoperative or not going to be applied. So that obligation would extend to a positive obligation to correct any false assumptions that the other party was obviously making, but it doesn't mean that they had to go out of their way to point things out. So in this case, on the facts, the court said that Tarmac hadn't done anything particularly wrong. It hadn't deliberately lulled Costain into thinking that the time bar was inoperative. It hadn't lulled it into thinking that they wouldn't try and run it later, and therefore, effectively, it was hard luck Costain here. So they lost out on a £6 million-ish claim because they'd failed to properly understand the terms of their contract. And their attempt to point the finger at the subcontractor for failing to do that didn't quite work. There's a general point as well, obviously, about NEC contracts that's worth mentioning, that there's quite a few time bars littered around the place, and we'll cover a few of those in today's talk. But generally speaking, the courts and adjudicators tend to be quite willing to uphold the time bars in NEC contracts. And that's consistent with the whole ethos of NEC contracts, which is to try and get things dealt with at the time rather than leaving things till later to sort out after the project's done. The next case is also a clause 10.1 case, and this is Van Ord and Drogados. So Drogados was the main contractor on the Aberdeen Harbour expansion, and it employed Van Ord to carry out some soft dredging works under the much used NEC3 ECC subcontract. Now, for some reason, although reasons are unclear, Drogados decided to omit work from Van Ord's package and gave it to other contractors. Now, it's fairly well established that doing that is a breach of contract unless there's an explicit right to do so in the contract, which there isn't here. So Drogados, I think, accepted that it was in breach of contract, but it tried to raise the novel argument that Van Ord's claim for lost profit wasn't going to work because the only way of assessing the damages was pursuant to the compensation event mechanisms in the contract. Now, an omission of works under the compensation event provisions reduces the prices, which is the total payable, under clause 63.10, says if the effect of a compensation event is to reduce the total defined cost and the event is a change to the subcontract works information, the prices would be reduced. So in effect, what Drogados was saying was, well, even if we're in breach of contract for omitting these works and giving them to someone else to do, you don't recover anything because overall the amount of work you're doing is less, and clause 63.10 means that that's a total, effectively you just lose out on the money and don't have any damages claim. Now, perhaps surprisingly, the court, and it's probably worth mentioning this is a Scottish case, so not immediately binding in England and Wales, although potentially, the court agreed with Drogados and said that although the omission was a breach of contract, it was correct to say that the only mechanism to value that was under the compensation event mechanism, because one of the compensation events is a breach of contract. And that was the case even though it meant that Van Ord was subject to reduced payment because of a reduction in prices as a result of Drogados' breach of contract. Now the final bullet point there says fair, ? And I would say it's pretty clearly not fair, particularly when there is no explicit contractual provision to that effect. And I'm pleased to say the appeal court agreed. So it said that although it was correct that the compensation event mechanism applies, there was another clause to look at, which is clause 63.2. And that says the prices are not reduced except as stated in this contract. So it said that properly understood, clause 63.10, which is the clause we just looked at and was the basis of the lower court's decision, only applied to lawful changes, and it excludes instructions that were issued in breach of contract, and said it concluded that clause 10.1 and 63.10 were counterparts. Unless Drogados fulfilled its duty to act in a spirit of mutual trust and cooperation, it could not seek a reduction in the prices. And as I said on the previous slide, I think that's a fair outcome, and it aligns with other principles which are well known about, for example, the prevention principle, the idea that one party can't rely on its breach of contract to its benefit, and also the need for clear language to be in the contract if one party is to give away something like a claim for damages. The court also had some good words here, which again the NEC fan club will, I'm sure, refer to in the future in adjudications and court proceedings, where it said, in our view, clause 10.1 is not merely an avowal of aspiration. Instead, it reflects and reinforces the general principle of good faith in contract. So it really does reinforce the idea that the courts think clause 10.1 is an important provision in NEC contracts, and they will do their utmost to try and make sure that parties do act in a spirit of trust and cooperation. Although, as pointed out in the Costain and Tarmac case, the first case, there is a potential limit there. And with that, I'll pass you on to Carolyn.
So the first case that I'm going to talk to you about this morning is Doosan Empire against Interserve Construction. And this case turns on the correct application of the paying gain share mechanism under an NEC 3 option C contract. So this case concerns the upgrade of water treatment works in Northumberland. The employer was Northumbrian Water Limited, and the contractor was actually a joint venture. So the contractor was a joint venture between Doosan and Interserve, and it was the contractors that ultimately fell into dispute, and the two contractors that this case concerns. So the contractors entered into an NEC 3 option C contract with Northumbrian Water, which is obviously a target cost contract with an activity schedule. And within that contract, there was a paying gain share mechanism, which covered what was happen in the event the target cost was exceeded or potentially bettered. The contractors also entered into a separate joint venture agreement amongst themselves. Now, the joint venture agreement contained several clauses in relation to payment. One of those clauses being that the contractors would make the normal interim applications in the usual manner under the NEC 3 contract. Those applications were to be effectively split to show monies applied for by Doosan and the monies applied for by Interserve, and then there would be a total due from the employer. The monies would then be paid by the employer into a joint account, and then the contractors would subsequently agree the monies to be paid out of that joint account to them individually. The joint venture agreement didn't ultimately amend any of the contract terms in relation to payment under the NEC 3, they simply supplemented them. So this interim payment procedure worked fine up until the point of payment number 31. Payment application 31 was submitted in the usual manner. The employer certified the full amount applied for and made payment into the joint bank account. At that point, Interserve blocked any payment from the joint bank account to Doosan. And Interserve's argument for doing that was that Doosan had effectively already been paid all that it could expect to achieve under the contract due to the paying gain share mechanism that had been agreed under the NEC 3 contract. So Interserve said, no, any further monies are not being paid to you out of this joint account, and under the joint venture agreement, Interserve was entitled to block such payments. The result of this meant that over £5 million was being withheld from Doosan, and Doosan, unsurprisingly, commenced a court claim. Now, just a bit of background explanation as to the paying gain share mechanism under NEC. I'm sure most of you are aware of it, but essentially parties agree on a target cost or price, and then upon completion, an assessment is made of the price for the work done, and then any overrun or cost saving is allocated according to the agreed formula. In this case, Doosan commenced a court case and then applied immediately for summary judgment on the basis that they said Interserve simply didn't have a defence. And the key clause that Doosan relied upon is clause 53.3 of the NEC contract, which I have placed on the slide before you. I won't read the entire clause to you, but as can be seen, the clause clearly states that any paying gain comparison has to be carried out at completion and once the price for the work done has been finally established. The court agreed with this. They said paying gain share cannot be applied at an interim payment, and therefore they awarded Doosan judgment of the 5.3 million. Now, some things to think about from this case. If employers wish to make use of any paying share before completion, amendments to the standard form are required, because this case makes clear, even if it becomes evident during interim applications that a contractor is potentially going to be overpaid, the NEC contract does not allow for any monies to be withheld due to the paying gain share operation until after completion. Also worth considering for contractors entering into any joint venture agreement, that it should be clear as to how interim payments should be apportioned between them, especially if there is a pain or gain share mechanism that ultimately otherwise wouldn't be applied until the end of the project. The next case I'm going to talk to you about this morning is Farrelly against Byrne brothers. So this case concerns the assessment of compensation events, which is a very common theme of dispute under the NEC contract suite. This matter concerned the refurbishment of Hammersmith Underground Station. London Underground was the ultimate employer. They appointed Byrne as main contractor, and then Byrne appointed Farrelly under an NEC 3 subcontract that was relatively heavily amended to do the M&E work. The parties fell into dispute as to the assessment of numerous compensation events and what monies Farrelly were entitled to under the subcontract. And it resulted in Farrelly commencing an adjudication. Now, Byrne argued at the adjudication that compensation events should all be assessed retrospectively. So Farrelly were only entitled to their actual costs incurred, but also that Farrelly were in concurrent delay, and therefore all time-related costs associated with the compensation events should be discounted. Now, the key clause under NEC 3 in relation to assessing compensation events is clause 63.1. Again, that clause is on the slide for you. Now, essentially, this clause says that when you're assessing the effect of a compensation event, the effect is split. So you look at the effect of the compensation event on work already carried out, and that is the actual effect on the defined cost. And then you look at the effect on work not yet done. And for any work not yet done, you apply a forecast cost. Now, the split between those actual costs and forecast costs is said to be the date of the instruction or the date that the compensation event is notified. Now, in this instance, the adjudicator actually sought an additional submission from both parties during the adjudication as to whether the compensation events should be assessed on a retrospective or prospective basis. And both parties put in a submission as to their opinion on the application of clause 63.1. Unsurprisingly, Byrne said all costs should be assessed on a retrospective basis, and therefore Farrelly were only entitled to their actual costs incurred. Farrelly said the opposite, and that forecast costs should apply. Byrne also argued, as I previously noted, that due to concurrent delay, Farrelly's time costs should be not paid. So the adjudicator held, having looked at clause 63.1 and the parties' submissions, that the majority of the compensation events that were in dispute in this adjudication should be assessed on a prospective basis, which is ultimately what NEC promotes. As Ollie mentioned earlier, the whole ethos behind NEC is that things should be sorted out as and when they arise to prevent your typical kitchen sink dispute on completion, which is often associated with JCT. The adjudicator also held that Farrelly were not in concurrent delay, and so they could claim their time-related costs. And his reasoning for this was because he has decided that the compensation events should be assessed on a prospective basis, he could not then retrospectively disallow time-related costs because of any alleged concurrent delay. He said Byrne's evidence to prove concurrent delay was based on a retrospective analysis, which could not be right. He therefore awarded just over £500,000 to Farrelly. Byrne refused to pay, and the matter then went to enforcement. Byrne resisted enforcement on two grounds. Firstly, Byrne argued a breach of natural justice. Byrne's points in this regard related to the fact that the adjudicator, after seeking submissions on whether the compensation events should be assessed prospectively or retrospectively, had then not sought separate submissions on the switch date, or how the assessment of compensation events then affected any conclusion on concurrent delay. Byrne also argued that even if the decision were enforceable, it should be stayed because Farrelly was in a poor financial position. And one of the main points that Byrne sought to rely on in this regard was that Farrelly was in dispute with numerous other main contractors, which could potentially have an effect on Farrelly's financial status in the near future. Farrelly argued in relation to the natural justice argument that Byrne had waived the right to argue this because, rather unusually in this adjudication, the adjudicator actually issued a draft decision, which was by agreement of all the parties, 2 weeks before the final decision was issued. And at the point at which that draft decision was issued, Byrne did not make any argument as to a breach of natural justice. But the court said no. Byrne hasn't waived the right to argue this, but there was no breach of natural justice. The court came back to the principle that for a breach of natural justice in this regard to have occurred, an adjudicator must have gone off on a frolic of his own. And in this instance, the court decided the adjudicator had not done that. And the court's reasoning behind this was that the adjudicator was entitled to find a conclusion in relation to the concurrent delay based on the principle of the argument as to the retrospective or prospective analysis of the compensation events. The court also then went on to say that no stay would be permitted. And the key in relation to arguing for a stay for financial reasons is really whether the party's financial position has changed from the point at which the parties entered into contract. The court wasn't interested in the fact that Farrelly had numerous other disputes going on at the time. The court was interested in the party's financial position at the point at which they'd entered into contract, and that had not changed. And the court also confirmed in this case as a general principle that there is no general obligation on a party seeking enforcement to disclose its financial position when doing so. The case of Farrelly and Byrne is still good law, and it's, as I said, it follows the principles of clause 63.1 of the NEC contract. But there has been a subsequent case, which I'm now moving on to, which is Northern Ireland Housing Executive against Healthy Buildings, which in part at least does further the court's decision in this regard. Now, this is a Northern Irish case, but it does likely ultimately apply in the English courts. Again, this concerned the assessment of compensation events. In this case, Healthy Buildings were appointed by the Northern Ireland Housing Executive under two separate NEC 3 professional services contracts to carry out asbestos surveys on the Northern Ireland Housing Executive's housing stock in Belfast. Now, for the purpose of the dispute, the two contracts were identical and the circumstances under both contracts were also identical, and therefore the court treated it effectively as one contract for the purpose of determining the dispute. Now, in this instance, Northern Ireland issued an instruction in January 2013, which changed the scope under the contracts. But they did not expressly request a quotation for a compensation event. In May 2013, so 4 months later, Healthy Buildings, after completing all of the works, notified Northern Ireland that a compensation event had occurred. Healthy Buildings then submitted quotations, all of which were rejected, and Northern Ireland said there had been no compensation event. Now, Healthy Buildings referred the matter to adjudication and won. And at adjudication, the costs of the compensation event were assessed on a forecast basis. So following the case of Farrelly and Byrne, this is probably not surprising. Now, Northern Ireland Housing Executive paid the adjudicator's decision, but then commenced a separate court claim. Now, initially, the case went to the Northern Ireland High Court, And the High Court found as a preliminary point that Healthy Buildings' claim was made out of time, and therefore the case was dismissed. Ultimately, the court found that because Healthy Buildings had not notified of the compensation event within 7 weeks of it occurring, they were not entitled to any additional time or costs as a result of it. Now, this obviously, I'm sure to a lot of you, will come as somewhat of a surprise, and unsurprisingly, this was overturned by the Northern Ireland Court of Appeal. Now, the principle under NEC 3 is that where there has been an instruction, the instruction itself is a notification of a compensation event, and therefore there was no time bar on Healthy Buildings' claim for additional monies as a result of this instruction. The Court of Appeal then had to consider 2 further questions. Ultimately, did the NEC contract allow the court to look at actual costs or simply forecast costs? And did the NEC contract allow for the assessment of events by utilising actual costs? Healthy Buildings relied on clause 63.1 to say that the forecast costs apply. Now, as we said before, the date that divides forecast costs and actual costs is the date of the instruction. So in this instance, instruction was given, all the subsequent work was carried out, and Healthy Buildings said it was entitled to rely on a forecast assessment of those costs at the date of the instruction. Healthy Buildings also relied on clause 65.2, which says that an assessment of a compensation event is not revised if the forecast upon which it is based is later shown to have been wrong. But Healthy Buildings lost. And the court in this instance relied on the Bulfer principle, which comes from an 1890s case in the House of Lords, which effectively states that knowledge overrules speculation. There's quite a famous quote from this case on the screen. The court said, "Why should I shut my eyes and grope in the dark when the material is available to show what work they actually did and how much it cost them?" So the court said the assessment has to be retrospective in circumstances where the work has already completed and the parties know the precise cost of carrying out that work. Now, this case came as a surprise to many NEC commentators because the court's decision seemed to go against the direct principle in clause 63.1, which promotes, obviously, the assessment of compensation events at the time that they occur. Many commentators also expressed concern that this would prompt employers to delay assessment of compensation events in the hope of potentially saving costs by relying on actual costs at the end of a job. Now, from my perspective, dealing with disputes that have arisen under NEC, I don't necessarily think there's been an increase in employers delaying assessment of compensation events, but I have definitely seen an increase in parties relying on this case where compensation events haven't necessarily been agreed at the time. Interestingly, however, due to current market conditions, it's probably more in contractors' benefit at the moment for assessments to be carried out on a retrospective basis, because obviously in the current market, forecasting costs can be extremely difficult and problematic. Just as a point as well, the court said in relation to clause 65.2 that clause did not apply here because that clause relates to the implementation of a compensation event, not the assessment of it. And so in circumstances where no assessment has been made, that clause is wholly irrelevant. So this case doesn't necessarily overturn Farrelly and Byrne. Farrelly and Byrne is still good law in relation to compensation events where the work has not yet been completed, as is clause 63.1, and the parties are still encouraged to follow that. But in circumstances where a compensation event has not been assessed at all and the work has been completed, the court's preference now is to use actual costs to assess the impact. So I'll now go back to Ollie for his next case.
Right, so 6 cases for the price of 1 in this one. This is ITI and Merrill Technology, probably the most well-known about substantive case on NEC contracts. And as I'd suggest, it's a bit of a saga. So just some very, very brief facts. ICI employed Merit to construct or partially construct a new paint manufacturing facility in Northumberland. It started out on quite a small project, just around £2 million for the contract works, and it massively increased. Even on ICI's case, the variations took it to in excess of £10 million. Realistically, they were saying £15 million, and Merit was asking him for north of £20 million. So from a contract which started out at £2 million, you can see potentially why things started to go wrong quite quickly. Contract was ultimately terminated in February 2015, and one of the issues in adjudication and the later court decision was who was in breach there, and ultimately Merit won that point. But unfortunately, Merit was forced into insolvency by ICI as a result of what happened in this job and its claim for payment. So the claim was ultimately issued, or the first claim was issued in late 2015. There's a sort of 6 reported judgments on the way. So we have a successful enforcement of an adjudication decision by Merit for about £800,000 in October 2016. Then the trial was postponed due to the effect of adjudications and lots of expert work, which pushed it out further. Merit got its costs paid there. There was a liability judgment in July 27, where Merit won in almost all of its case then. There was then a cost judgment where Merit was ordered all its costs of the liability case and also got permission to amend its quantum case. And then finally, there was the quantum judgment on 21st of June 2018, where ICI were awarded £2 million and again its cost. So Merit, to be honest, won at pretty much every turn, and ICI were clearly fighting things, to the absolute bitter end. It's a case that's well worth reading. Certainly the liability and the quantum judgment. There's some quite explosive comments in there, criticism of expert witnesses, criticism of factual witnesses, and general disapproval by the court of the way the parties went about this, in particular ICI, because I think it's fair to say Merit were much the innocent party in these things. But if you've got some time in your hands, if you're looking at some bedtime reading as the winter sets in, then I would wholly recommend these 2 cases, although I'm aware that a lawyer's recommendation of reading material might go with a pinch of salt. Anyway, there's a couple of points specific to NEC3 that I want, or NEC contracts in general, that's worth pulling out of these decisions. And the first is who can be the project manager. So under the form of contract that was agreed, the project manager was named as Progen, an independent consultancy that are fairly well versed in producing process plants like this. And specifically, a chap called Andy Barton was the named project manager. Now, he resigned somewhere into the project in October 2014 after he was told that all variations and instructions had to be approved and signed off by a member of the Akzo Nobel site staff, that being ICI's parent company. Now, he, as I say, resigned in October, but some months before that, in July 2014, Mr. Boerboom of Akzo Nobel was parachuted in because the project was going wrong, and he was supposed to be a trouble fixer. So he started to implement this regime of making sure variations were signed off by the employer, and eventually took over, or claimed he took over, as the named project manager. And the court was pretty scathing of this, it's fair to say. It found that he was parachuted in to the project and decided the best way to bring the project cost down was to push Merit into insolvency. And it said his purported appointment as project manager was clearly invalid. He actually said he was eminently unsuitable to act as the project manager, and from all the evidence I have seen, did not remotely at any stage attempt to do anything other than fulfill the employer's purpose, which was to reduce expenditure on or exposure to Merit by forcing the company into insolvency. And the judge also said that he was eminently unsuitable in every single respect and was the very opposite of independent. So pretty scathing of his approach. And ultimately, what it really means is, if you're going to try and appoint a new project manager halfway through the project under NEC, you're going to need agreement or potentially a bespoke provision in the contract in advance that allows one party to do that. But even that might be questionable, where the idea of the project manager is they need to be independent. The second issue I wanted to look at was the idea of revisiting assessments. So Merritt's case was that where the project manager had reached an assessment of the compensation event, ICI was precluded from challenging that. And in putting forward that argument, it pointed to clause 65.2, which said the assessment of a compensation event is not revised if the forecast upon which it is based is shown by later recorded information to have been wrong. Now, the judge said that wasn't right. It was pushing it too far, and pointed in particular to clause W2.3, which is one of the adjudication provisions. And this is a similar provision to what we have in the scheme. It says the adjudicator may review, revise any action or inaction of the project manager. As there was nothing in the NEC form which made any assessment on a CE binding, in contrast to some forms of contract where you do get conclusivity provisions, there was no reason why the adjudicator couldn't open up any decision on a compensation event. And that was also consistent with the idea that the court has a general inherent jurisdiction to be able to look at anything which was done and open it up and change the decision. So it was wrong to say that the assessment of a CE was binding forever. However, there was an evidential point also raised, and this was raised by Merit as an alternative argument, but ended up being the one that they won on. And they said, and I think this is quite a compelling point really, that the professional team acting on ICI's behalf, including Progen when they're a project manager, agreed to the different items during the project for a good reason, because they were agreed to be correct or appeared to be so. And it said that what ICI was in effect now looking to do was to come back after the event with people that didn't know the project, had no evidence, and no evidence that Mr. Barton was incompetent, him being the Progen project manager, and try to say, look, their benefit of hindsight was the better way to do it. And the court said that was a compelling evidential argument, and it said, in terms of logic, it was an unanswerable point. During the works, a great many personnel within ICI and the project manager himself conducted a vast number of different reviews and found that Merit's items of work were worth particular precise amounts. They decided with a detailed knowledge of the project what things were worth, what the subject of a PMI was, and how it should be fairly valued. And the court was pretty unwilling to look behind that. So although it didn't say that the compensation events assessments were, strictly speaking, binding, it did say that effectively there would have to be some pretty strong evidence that apart from those, and that was lacking in almost every respect. Another point to flag from this judgment is the judge listed out some of the reasons why the claims failed. And these aren't particularly NEC specific points, but I think they are worth mentioning. So the judge, towards the end of his judgment, realised or noted that he had sided with Merit on almost every quantum discussion, and was clearly conscious to make sure that he set out his reasons for that, so there was no prospect of him being suggested to be other than impartial. And he set out these 7 points, which I think we see time and time again in all sorts of adjudications and litigation environment, and no doubt you will have seen in project meetings and things like that, these kind of arguments being raised. And it's useful that the court gave them pretty short shrift. So he was saying ICI's position, which was to try and value the work, as I say, about £10 million compared to the £20+ million that Merit wanted, ignored agreements reached by Mr. Barton, the project manager, which is the point we just mentioned, ignored the schedule of rates, decided to use their own numbers there, which they said were more reasonable. It attempted to rely on a lack of substantiating documents to justify providing no figure at all. So rather than producing an assessment, it just said, I've not seen anything, so I'm going to value it at nil. And again, number 4 is the same point, that where there's work so clearly been done, putting forward an argument of nil is going to be unsustainable. There were general comments like there might be duplication put forward, which was not accepted. The expert witness on behalf of ICI put forward very, very low valuations with no evidential basis, which was heavily criticised by the court. And ICI had no factual witnesses who were involved, and that was telling. So these points are definitely points that are worth bearing in mind, and really just reinforce the idea that courts are not going to allow one party to effectively try and game the system by putting in unrealistically low valuations and in an attempt to try and pull one party down. And generally speaking, as I say, it's worth reading the judgment, because you can see that the courts were pretty scathing of ICI's conduct, and really just consider this to be not the way to run a project. And in closing, the court also noted that the litigation stood as something of an advertisement for adjudication, because after, as I say, 6 reported cases, goodness knows how many adjudications, and you shudder to think how much was spent in legal costs and management time on these claims, well into the millions of pounds certainly. Ultimately, the decision reached by the court was around 1% different from the amount that had been awarded in the adjudication process. So really it's saying, everyone has their gripe to the adjudication. Sometimes it can go very badly wrong, but generally speaking, the ICI merit case shows that adjudication is not all bad, and actually parties would be well advised to sit back and think very carefully before they push things through to expensive court proceedings where the number might well come out to be very similar. And with that, I think I'll pass back to Carolyn.
Okay, so the next case I'm going to talk to you about is Atkins against the Secretary of State for Transport. And this case concerns what might actually be deemed to be a compensation event under NEC. So, Secretary of State appointed Atkins under a heavily amended NEC 3 contract. It was a lump sum contract, and Atkins had been appointed to carry out maintenance work on trunk roads in East Anglia. Now, a dispute arose concerning the number of potholes requiring remediation. Probably not surprising for any of you that spend any time at all driving around East Anglia. Now, this case went round in circles a little. Initially, Atkins took it to adjudication, saying that the number of potholes constituted a compensation event, and the adjudicator agreed. It was then taken to arbitration, and the arbitrator overturned the adjudicator's decision. So Atkins then sought to challenge the arbitrator's award in court. Now, the clause in question was clause 60.111. Now, the clause is on screen there. The key point being that a compensation event occurs if there's a defect in the physical condition that an experienced contractor would have judged it at the contract date to have such a small chance of being present that it would have been unreasonable to allow for it. So if there's a difference between what would have been reasonable to have been allowed for and what was ultimately encountered, it can be deemed a compensation event. Now, the court found that the number of potholes did not constitute a compensation event. The court said there's nothing in the language of clause 60.111 which expressly suggested that the number of defects was an important element in the compensation event equation. So the court said there's no need to try and establish how many potholes is excessive. The test actually had to be applied to each individual pothole. So the court said a competent contractor would have assessed the risk of potholes being present as likely to occur, and therefore the fact that there were potholes does not mean there's been a compensation event. The court said this was a lump sum contract, so the risk of potholes being more or less in number was shared equally between the parties. Now, an interesting quote came out of this case, some Aikenhead's words of warning on NEC forms. Aikenhead said, some siren or other voices which criticise these conditions for some loose language, which is mostly in the present tense, which can give rise to confusion as to whether and what extent actual obligations and liabilities actually arise. Now, I'm not sure if listeners today are keen NEC fans or not, but I would say there's definitely some weight in Aikenhead's words there. The last case I'm going to talk to you today about is Balfour Beatty against Gill Comston. Now, this is a Scottish case that was heard in the Court of Session, and it actually concerned an NEC 2 contract and subsequent subcontract, albeit the principles are the same in the current suites. So just by way of background, Balfour Beatty were appointed to construct a cold store under an NEC contract, and they subcontracted with Gilcomston to carry out the cladding and steel framework. When the works were very nearly completed, a fire broke out and destroyed the entire premises. The fire was caused as a result of the works being carried out on site. And under the main contract, Balfour Beatty were required to rebuild the entire premises at their own cost. Balfour Beatty then sought compensation from Gilcomston, which is how this case came to rise. Now, the two relevant clauses in this case are on screen there, being clause 83.1 and clause 83.2. Now, 83.1 is a standard indemnity clause whereby each party indemnifies the other for any costs that arise for an event which is at his risk. 83.2 goes on to say that the liability of a subcontractor to indemnify the contractor is reduced if events at the employer's or contractor's risk contributed to the claims and costs, etc., and that the reduction is to be proportionate. Now, sorry, I'll go back a slide. In this case, Balfour Beatty argued that Gilcomston had to indemnify them for the entire cost of rebuilding the premises. Balfour Beatty argued that clause 83.2 was effectively rendered invalid by the presence of clause 83.1, and Balfour Beatty's position in this regard was that an indemnity cannot be qualified. Balfour Beatty's position in the alternative was that even if the indemnity is qualified by clause 83.2, clause 83.2 only applies in circumstances where there have effectively been more than one risk event, one of which was Balfour Beatty's risk and one of which was Gilcomston's risk, which had not occurred in these instances. Gilcomston were trying to rely on Balfour Beatty's negligence as being an event that reduced their liability under the indemnity clause, and Balfour Beatty said clause 83.2 did not allow them to do this. The court said no, and they agreed with Gilcomston. They said clause 83.2 is not limited or rendered effective in any way by the indemnity at 83.1. The two clauses are to be read together as the NEC intended. The court also said that the liability of a subcontractor for the occurrence of an event at his risk is reduced if there has been negligence on the part of the contractor. And with regards to Balfour Beatty's argument that the indemnity clause was not reduced by negligence, the court held for an indemnity clause to have the effect of indemnifying a party for the consequences of his own negligence, it must contain the word negligence or some synonym of it. And that was taken from the case of Smith against UMB Chrysler. So the court said no, Balfour Beatty is partly liable and Gilcomston only had to pay effectively their portion of the liability. The final point the court said, which was a bit of a side point, but they did confirm any failure to insure does not absolve any liability under an indemnity or otherwise. So I'll now pass back to Ollie.
Right, two more cases to go. And just a reminder, we've got the chat box open, so if you have got any questions, do pop them in and we'll try and address those in the few minutes we've got left at the end after these two cases. To finish off, I've got two cases on the dispute resolution provisions of the NEC form. The first one is another Scottish case, and it deals with dredging works to Fraserburgh Harbour. The works were completed by Mclaughlin and Harvey, but the employer alleged various defects and went straight off to court and issued a claim for £7 million. Now, the NEC has what's called a tiered dispute resolution mechanism, which sounds very grand, but in reality, all it means is that rather than going straight to court or arbitration, depending on which tribunal the form selects, you are required to go to adjudication first. And that's set out in clause W2.4, which makes it pretty clear that a party does not refer a dispute to the tribunal, that being court or arbitration, unless it has been first decided by the adjudicator in accordance with the contract. And then once the adjudicator has made their decision, if one party or both parties are unhappy with it, they can give a notification within 4 weeks, and only then can they go to court or arbitration. So clearly the employer here had skipped a stage, and unsurprisingly the contractor said, hold on, we need to go to adjudication first. And the court agreed. It said the provisions were intended to be definitive as to the means for determining any disputes between the parties and the sequence in which they were taken. And ultimately, that's a fairly unsurprising conclusion, I would suggest. The contract is pretty clear. The parties are free to agree to that, and equally, if they don't want to have the tiered provision in there, they're free to amend it. Although parties are generally discouraged from amending NEC forms, there's no reason why, in principle, you can do that. And I think if the employer's arguments had been successful and said they could go straight to adjudication, to court, rather than going through adjudication, it would have undermined the benefits that adjudication can bring to the parties, as we saw in the ICI and Merit case. It's worth mentioning as well that one of the reasons why the employer argued that the tiered dispute resolution system shouldn't work or shouldn't be enforced is because under the Construction Act, as you'll be aware, the parties have a right to refer disputes to adjudication at any time. And the employer creatively argued that that meant that there was also a right not to refer disputes to adjudication at any time. And the court said, well, that was just clearly wrong. There was no wording to that effect in the contract or the Act. And as I say, if the parties had wanted to not have the requirements, such as in JCT forms where there's no general obligation to go to adjudication first, then they could have agreed that. They must have chosen to do so for a reason, which was to get the benefits of an adjudication decision in the short term. So, simple takeaway here, the contract's clear, must be followed. Now the next final case is another enforcement case, RBG and SGL carbon fibres. So this is a classic situation which we see all the time where a subcontractor claims various invoices and refers those all to adjudication in one go. So in this case, it was RBG as a subcontractor engaged by SGL under the ECC subcontract form, I believe, claimed payment under various invoices over a period of many months in adjudication, and SGL said, well, we don't recognise the invoices, but also they're inaccurate because we've paid more than those in previous payment cycles. And it asked the adjudicator to look at the project as a whole, to look at the price of the work done to date and what had been paid, and resolve the dispute in that way. Now, somewhat curiously, the adjudicator refused to consider SGL's case as to what had been paid previously, and said that the notice was deliberately drafted narrowly by RBG and only gave him jurisdiction to consider specific invoices and what was due under them. Now, unsurprisingly, SGL was unhappy with that decision. It must have served its clause W2.4 notice within 4 weeks, as I just mentioned, and went off to court to challenge the enforcement and argued that there was either a breach of natural justice because the adjudicator had failed to consider a defence, or he had failed to exhaust his jurisdiction. Now, the failure to exhaust jurisdiction is a developing area of the jurisdiction argument. Usually it's where someone has gone outside their jurisdiction. Here, SGL was saying, well, the adjudicator stopped short of being able to do this, of doing what he could have done, because he was under a misapprehension as to what he was allowed to do under the notice, which, as I say, didn't include any reference to overpayments. And again, probably unsurprisingly, the adjudicator came down on SGL's side, and in a rare case where decisions wasn't enforced, it said the adjudicator had the power to and was bound to consider the allegations of overpayment because they were a bona fide defence. And it's fairly well settled case law now that where a party has a genuine defence in an adjudication, even if it's not included within the notice of adjudication, because why would a referring party put a defence in there, then the adjudicator must still consider it. And the court also noticed that actually the adjudicator had taken a fairly contradictory approach, because He had corrected some of the invoices because he thought the price of the work done to date was incorrect, but he just hadn't considered the employer's side of those arguments. So a bit of a mess, and it could well have been, looking at the judgment, because of the way the price of the work done to date is calculated in NEC forms, that the adjudicator got himself into a bit of a pickle and ultimately produced a decision which was unenforceable. So I think with that, sorry, just one final slide. Yeah, the court concluded the adjudicator could go behind the price for the work done to date. And there was also a point in this case, which was that apparently the project manager had agreed certain invoices, which goes back to what we said right at the start of, in the ICI case, where those agreements were not binding, although they were at least evidentially relevant for the adjudicator or the court looking at them. So yes, now we've got 2 or 3 minutes left for questions. No questions in the chat boxes yet, but we have had a couple in advance. I think, Carolyn, did you want to address the first one?
Yes, the first question that we had in was, how will the courts approach Z clauses that act as an extreme derogations from the standard wording of the NEC and in some cases appear to go against the spirit of the NEC? So I think the starting point in answering that question really is the court's general principle that it will enforce terms of contract that the parties have agreed. And the court has gone further than that on many occasions to confirm the principle that even if a party has effectively made a bad bargain when entering into a contract, the contract terms are still applicable, they still apply, and parties cannot get out of it in that sense. In the terms of clauses that act as extreme derogations from NEC, I don't think the courts would have any different approach to that. If parties have agreed terms, they still stand. The clause mentions extreme derogations from the standard wording of the NEC. Now, obviously, there's 2 potential ways that this could arise. If it is an actual bespoke amendment to the standard wording, then that bespoke amendment will stand. Alternatively, if there's an additional Z clause, which potentially is discrepant to what is in a standard clause that still remains, then it will fall on a case-by-case basis to determine which clause actually takes precedence. The ordinary position is that additional clauses that are added take precedence, but in some cases, obviously, that may be altered. But even if they tend to go against the general spirit of the NEC, express contract clauses will still stand. So I'll pass you to Ollie for the second question.
Yeah, so the other question we had in advance was, how strictly are the time-dependent condition precedents applied, both in law and in practice? I think I mentioned right at the start, NEC has lots of condition precedent clauses listed around it. The first case looked at one, and then obviously the compensation event notification is the biggest. My personal experience in adjudications and court proceedings is that they tend to be applied more rigorously than other forms. Particularly the compensation event notification, it's quite a long period, like 7 weeks under the subcontract, 8 weeks under the main contract as standard. And generally, adjudicators and courts are willing to hold people to that. Again, because the whole spirit of the NEC is about getting things done promptly rather than sitting on your hands and waiting to end the project. It seems to be under NEC more than other forms that parties are willing to, that tribunals are willing to hold people to those time periods. And then just before we go, one final question in on the chat box, which is, as a subcontractor, we qualify all indemnification clauses as subject to the limitation of liability clause. Is that effective? I would say, what do you think, Carolyn? I would say yes, as long as it's clearly drafted.
Yeah, exactly. As long as the limitation of liability clause is clear, then you can make an indemnification clause subject to that. Indemnification ultimately just reverses the standard of proof, so it makes it far more difficult to argue against something, but it wouldn't override any limitation of liability clause.
Okay, well, I think that brings us to a conclusion. Bang on 12. Thanks very much for joining us. As a reminder, we'll pop this up on our YouTube channel. Look out for LinkedIn for the next webinars that are coming up. And in the meantime, have a very good afternoon.
Thank you.